0. That is the number of major lawsuits that have ever been successfully brought against South Park. Not one. Not a single defamation claim, not a single copyright judgment, not a single verdict rendered against Trey Parker, Matt Stone, Comedy Central, or Viacom for any of the hundreds of real, living, identifiable public figures the show has spent nearly 3 decades systematically humiliating on national television. 0. And that number is not the starting point of tonight's conversation. It is the ending point. The entire video between now and then is an explanation of how that number is possible. Because once you understand how South Park maintains a perfect legal record while doing what it does, you understand something fundamental about the show that has nothing to do with comedy and everything to do with the invisible architecture of American law. Think about what South Park has done. This is a show that has depicted Tom Cruise refusing to come out of a closet while the entire town begs him to emerge. A show that has portrayed Kanye West as a man who cannot comprehend a fish stick joke. A show that has animated the Prophet Muhammad in a bear suit, Barbra Streisand as a mechanical dinosaur, Paris Hilton in situations that cannot be described on a family-friendly platform, and the Pope personally overseeing criminal enterprises. A show that has called real, named, powerful people things that would get a newspaper shut down and a private citizen bankrupted by legal fees. A show that, in its 200th episode, gathered every single celebrity it had ever mocked into a single crowd and had them threaten to file a class action lawsuit against the town itself, which is either the most audacious piece of self-aware television ever produced or the most reckless invitation to litigation in broadcast history. Probably both. And not one of those people has ever won a dime in court. That is not an accident. That is not luck. That is the product of an animated series that understands American law better than most law firms and has been quietly teaching its audience about the First Amendment, contract law, copyright doctrine, defamation standards, and the machinery of civil litigation for over 25 years, all while pretending to be nothing more than a show about 4 foul-mouthed children in a small Colorado town who cannot seem to stay out of trouble. This is Paper Town. Settle in. Tonight is going to be a long one. Tonight, we are going to watch South Park the way a lawyer watches it. Not for the jokes, not for the satire, not for the cultural commentary, for the arguments. Because buried inside this construction paper cartoon, sewn into the fabric of episode after episode, across every era of the show, there is a remarkably sophisticated body of legal commentary that most viewers walk past without even noticing. The show has created a legal defense strategy that entered actual courtroom vocabulary around the world. It has generated a federal appellate ruling that changed how judges across the United States handle copyright cases. It has deployed an obscure defamation deterrent so effectively that legal scholars now cite the show as a case study in their journal articles. And its resident lawyer character, Gerald Broflovsky, is one of the most quietly devastating portraits of the American legal profession ever put on television. A portrait that becomes more uncomfortable the longer you look at it, because the uncomfortable thing is not that Gerald is corrupt. The uncomfortable thing is that he is competent. So tonight, we are going to find all of it. Every piece, every episode where the law is not just referenced, but anatomized. Every moment where what looks like a throwaway joke is actually a precise legal observation. And by the end, the thing that will stay with you is this: that for a show built on toilet humor and cutout animation, South Park might be the most legally literate program in the history of American television, and it has been this way since 1998. Before we move on, if you are enjoying this rearisis, please consider subscribing. It helps the channel tremendously. The place to begin is with a sentence that no law school teaches, but every practicing attorney in the United States has heard at least once. If Chewbacca lives on Endor, you must acquit. That line comes from Chef Aid, Season 2, Episode 14 of South Park, which aired on Comedy Central on October 7, 1998. The episode was written by Trey Parker and Matt Stone, directed by Parker, and it features a cast of musical guest stars, including Elton John, Ozzy Osbourne, and Meatloaf. But the guests are not the reason the episode matters. The reason the episode matters is a fake legal argument that became a real one. The premise of Chef Aid is a copyright dispute. Chef, the school cafeteria worker beloved by the children of South Park, discovers that a hit song called Stinky Britches, performed by Alanis Morissette, is actually a song that he wrote 20 years earlier. He has a recording to prove it. He contacts the record company, identified in the episode as a major label, seeking only to have his name credited as the composer. He is not asking for money. He is not threatening litigation. He simply wants acknowledgement. The record company responds not by acknowledging Chef's claim, but by hiring Johnny Cochran, the show's fictional version of the real attorney who represented O.J. Simpson, in filing a lawsuit against Chef for harassment. The inversion is immediate and total. The person whose intellectual property was stolen becomes the defendant. The corporation that stole it becomes the plaintiff. And the weapon the corporation uses is not evidence. It is a lawyer. In court, Gerald Broflovski represents Chef. Gerald's case is strong. Chef wrote the song. Chef copyrighted it. The record label used it without permission or credit. Gerald presents logic, evidence, and the law. In any reasonable courtroom, this would be enough. But Cochran does not operate in a reasonable courtroom. Cochran operates in the space between reason and persuasion. And in that space, he deploys the argument that would make South Park history. He holds up a picture of Chewbacca, the Wookiee from Star Wars. He tells the jury that Chewbacca is from the planet Kashyyyk, but lives on the planet Endor. He asks why an 8-foot-tall Wookiee would want to live on Endor with a bunch of 2-foot-tall Ewoks. It does not make sense, he says. And then he asks the jury what any of this has to do with the case they are deciding. Nothing, he admits. Absolutely nothing. He is a lawyer defending a major record company, and he is talking about Chewbacca. Does that make sense? No, it does not make sense. None of this makes sense. And so, if Chewbacca lives on Endor, you must acquit. The jury acquits. Chef loses everything. The scene plays as absurdist comedy, and it is absurdist comedy of the highest order. But strip away the laughter, and what you are looking at is a shockingly precise dissection of how corporate legal power actually functions in the American system. The record company does not win because its case is stronger. The record company wins because it can afford a lawyer who is skilled enough to make the jury forget what the case is about. Chef has the law on his side, the copyright documentation on his side, and the evidence on his side. None of it matters because the process itself has been corrupted. Not through bribery, not through witness tampering, not through any criminal act, but through sheer rhetorical manipulation, deployed with enough confidence and showmanship that 12 ordinary people sitting in a jury box lose track of the question they were supposed to be answering. The show does not editorialize about this. It does not have Kyle deliver a speech about justice. It does not have Stan say, "I learned something today." It simply shows you what happens when one side of a legal dispute has enough money to hire someone whose professional skill is not finding the truth, but obscuring it. The comedy is the rheresis. The joke is the argument, and the argument is devastating because it is not wrong. What a lawyer notices, watching this scene in 1998, is how precisely the show understands the difference between the law as it is written and the law as it is practiced. Written law says Chef should win. In theory, copyright protections exist to prevent exactly what happened to him. But practiced law says the party with the better lawyer wins, because the law is not self-executing. It requires human beings to interpret it, and human beings can be confused, distracted, entertained, and overwhelmed. The Chewbacca defense is not a fantasy. It is an exaggeration of something that happens in courtrooms routinely. Lawyers introducing tangential evidence, emotional appeals, or procedural complexity to overwhelm a jury that does not have the training to separate relevant information from irrelevant spectacle. The fact that the jury in the show falls for it is not the joke. The joke is that anyone watching at home is surprised. And then there is the aftermath. After Chef loses the case and faces financial ruin, the boys organize a benefit concert to raise money. Cochran, moved by the children's effort, agrees to represent Chef pro bono. He uses the Chewbacca defense again, this time on Chef's behalf, and wins. The record company is forced to acknowledge Chef's authorship. During this second deployment, Cochran takes out a monkey puppet and shouts, "Here, look at the monkey, look at the silly monkey," until a juror's head literally explodes from the confusion. There is a detail in this reversal that most viewers miss entirely. The same strategy that was used to pervert justice in the first trial is used to restore justice in the second trial. The Chewbacca defense is not inherently evil. It is not inherently good. It is a tool. And like any tool, its moral character depends entirely on who wields it and for what purpose. justice. Gerald's legal skill and evidence were not enough to overcome Cochran's rhetoric in the first trial. Cochran's rhetoric was enough to overcome the record company's legal position in the second trial. The system does not care about justice. The system cares about persuasion. That is not a comedy observation. That is a jurisprudential one, and it is the kind of observation that first-year law students spend an entire semester trying to articulate in their legal philosophy courses. South Park said it in 22 minutes with a puppet monkey. Years later, the term Chewbacca defense entered actual legal discourse, not as a joke, as vocabulary. A man indicted on federal tax fraud charges in Florida attempted a defense so disconnected from the evidence against him that the federal prosecutor directly referenced South Park. "And I do not want to seem flip," the prosecutor said to the jury, "but some of you may have seen it. I think it is a South Park episode." The reference was understood. The defense failed. But the fact that a federal prosecutor in an American courtroom could invoke an animated sitcom and have the invocation function as legal shorthand, as a term of art that every juror in the room recognized, tells you something about how deeply this show has embedded itself in the professional vocabulary of the people who operate the American legal system. The reach extends further than a single courtroom in Florida. In a 2009 Swedish trial against 4 men who had co-founded the Pirate Bay, the defense attorneys constructed what was described as the King Kong defense, a rhetorical strategy that bore the unmistakable genetic signature of the Chewbacca defense. The defense argued that the founders of the Pirate Bay could not be held personally responsible for copyright infringement committed by other users of their platform, and they framed this argument through a deliberate rhetorical strategy of introducing irrelevant and confusing information to muddy the legal waters. The legal blog commentary at the time drew the direct line back to South Park. The show did not just satirize a legal strategy, it codified it. It gave it a name. It made it recognizable. And codification, giving something a name that sticks, is itself a kind of legal act, because the law depends on language, and language is shaped by the culture that produces it. South Park is part of that culture now, whether the legal profession likes it or not. Lawyer Josh Gilliland, writing on his legal blog, rearized the Chewbacca defense in detail and noted that a judge would likely declare a mistrial if such an argument were actually made in court. He also observed that a party successfully using the strategy to confuse a jury runs the risk of the losing party winning on a judgment, notwithstanding the verdict. In Chef's case, Gilliland argued, the copyright violation should have entitled Chef to a judgment as a matter of law. The legal rearesis of a cartoon courtroom scene, published on a legal rearesis blog read by practicing attorneys, treated the fictional trial with the same rearitical rigor that would be applied to a real case. That tells you everything about what South Park accomplished with this episode. The gap between what the show looks like and what the show does is the entire subject of tonight's video essay. On the surface, Chef Aid is a silly episode about a man in a tall chef's hat fighting a record label, while Ozzy Osbourne bites the head off a bat at a benefit concert. Underneath, it is one of the most accessible explanations of intellectual property theft, litigation asymmetry, and the weaponization of legal process ever broadcast on American television. And it aired in 1998, when most of its audience was still in middle school, absorbing a sophisticated critique of the legal system without realizing they were being taught anything at all. That tension between surface and substance is the engine that drives nearly every legal moment in South Park, and nowhere is it more persistent, more layered, or more uncomfortable than in the character who has been quietly litigating in the background of this show for over 2 decades. Gerald Broflovsky is Kyle's father. He wears an olive green jacket over a purple shirt and forest green trousers. He sports a contemporary beard and a separated mustache. He is almost always wearing a pink yarmulke. He is, in most episodes, a reasonable and caring parent, the kind of father who worries about his son's moral development and takes an interest in local civic affairs. He is voiced by Matt Stone, and the character is named after Stone's own father, Gerald W. Stone, who was, in real life, an economics professor rather than a lawyer. But in the show, Gerald is an attorney. He operates out of the firm of Broflovsky and Jackson, which first appeared in the Season 3 episode Spontaneous Combustion, and he also serves as the city attorney for South Park. It is in that second identity, the professional identity, that South Park conducts its most sustained and most uncomfortable legal rearesis. Because Gerald is not a bad lawyer. He is, by every measurable standard, a good one. He won the Stinky Britches case on the second try. He navigated the Apple terms and conditions labyrinth to free his own son from a corporate nightmare. He serves on the city council. His colleagues trust him. His clients win. And it is precisely because he is good at his job that the show's portrait of him is so damning. Because the show is not arguing that the legal system is populated by incompetent people. It is arguing that the legal system is populated by competent people whose competence can be directed toward any purpose, and that the purpose it is most commonly directed toward is the enrichment of the lawyer. Sexual Harassment Panda, Season 3, Episode 6, which aired on July 7th, 1999, is the episode where this argument is made with surgical clarity. The episode was written and directed by Trey Parker. According to the DVD commentary, Parker and Stone were so exhausted from making the South Park movie, bigger, longer, and uncut, which had just been released, that they have no memory of making this episode. That exhaustion does not show. The episode is one of the most precisely constructed satires of litigation culture the show has ever produced, and Gerald Broflovsky is at its center. The episode begins with a school assembly. A man in a panda costume called Petey the Sexual Harassment Panda visits Mr. Garrison's third grade class to teach the children about sexual harassment. The presentation is well-intentioned. It is also legally accurate. Sexual harassment is real. It causes real harm. The laws against it serve a real purpose. But the show is not interested in the purpose. The show is interested in the application, in what happens when legal knowledge is placed in the hands of people who lack the context to use it responsibly. Stan calls Cartman an offensive name. Cartman, having just learned that name-calling constitutes sexual harassment, sues Stan. Gerald Broflovsky is Cartman's attorney. In court, Cartman delivers a wildly exaggerated account of the emotional damage Stan's words caused him. He cries. He implies that Stan wanted to engage in sexual acts with him. Principal Victoria is called to the stand, and, in a state of paranoia, accidentally confesses to an unrelated murder before confirming that sexual harassment does occur at the school. Petey the Panda testifies about the relevant laws. The judge rules in Cartman's favor. Stan is ordered to give Cartman half his possessions. Cartman does a victory dance. But the episode does not end there. It cannot end there because the show understands that a single lawsuit is not a problem. A single lawsuit is just a lawsuit. The problem is what happens when a single lawsuit demonstrates that the system can be exploited, because then the exploitation becomes a business model. Gerald sees the victory and recognizes its implications. If Cartman can sue Stan for name-calling, then any student can sue any other student. And if any student can sue, then Gerald can represent them. Gerald begins encouraging more lawsuits. He runs a television commercial advertising his services to students who have experienced sexual harassment. The commercial features testimonials from children who have won settlements. BB won $1.6 million. Clyde won $1.4 million and is seen on a cruise ship surrounded by women. The school, forced to pay these settlements, begins cutting costs. Programs are eliminated. Staff are laid off. Petey, the Sexual Harassment Panda, is fired. Mr. Garrison writes on the chalkboard with a rusty nail because the budget can no longer cover chalk. The screeching sound fills the classroom. Then, Pip sues Cartman. The system that Cartman exploited now exploits Cartman. Pip wins half of Cartman's belongings and a $1.6 million settlement. The hunter becomes the hunted. Everyone in South Park is suing everyone else, and Gerald Broflovsky is representing all of them, collecting fees from every case, moving his family into progressively larger houses as the school system collapses around him. A lawyer watching this episode notices something that most viewers do not notice, because most viewers are not trained to notice it. Gerald is not breaking the law. At no point in the episode does Gerald do anything illegal. He is representing clients who have what the law considers legitimate claims under the sexual harassment statutes as they exist. He is filing suits that the courts are accepting. Juries are awarding damages. The system is functioning as designed, and that is the point. The episode is not arguing that the law is being broken. It is arguing that the law, when operating exactly as intended, can still produce outcomes that are profoundly destructive. Gerald's behavior in the episode is what the legal profession calls ambulance chasing, the practice of soliciting clients, often vulnerable ones, for the purpose of generating litigation fees. It is ethically prohibited by bar associations across the country. Model Rule 7.3 of the ABA's Model Rules of Professional Conduct restricts in-person solicitation of prospective clients when the lawyer's significant motive is pecuniary gain. But the show is careful, almost certainly by instinct, rather than by research, never to show Gerald crossing a clear ethical line in a way that would be easily identifiable to a non-lawyer. He does not fabricate claims. He does not coach witnesses to commit perjury. He does not bribe judges. He simply makes himself available, encourages people to exercise their legal rights, and takes his percentage. The corruption is structural, not personal. Gerald is not evil. Gerald is incentivized. And the distinction between evil and incentivized is one of the most sophisticated legal observations the show has ever made, because it shifts the moral hierarchy from the individual to the system. The episode's resolution comes from an unlikely source. Petey the sexual harassment panda, fired from his job and exiled to the Island of Misfit Mascots, a parody of the Island of Misfit Toys from Rudolph the Red-Nosed Reindeer, returns to South Park under a new name, Petey the Do Not Sue People Panda. He delivers a speech to the assembled citizens of South Park, and the speech is worth paying attention to because it is doing something that South Park rarely does, which is to state its thesis directly rather than allowing the audience to infer it. You sue for money, Petey says. But where do you think that money comes from? From the schools? From taxes? From the state? From you? There is no such thing as free money. When you sue somebody, you take money away from parks and schools and charities and put it in your own pocket. That speech is simple enough for a child to understand. It is also, in its essentials, a summary of the law and economics critique of tort litigation that was being vigorously debated in American legal academia throughout the late 1990s. Scholars like Richard Posner and Guido Calabresi were publishing work on the social costs of excessive litigation, arguing that the tort system, while serving the essential function of compensating injury, could also impose costs on society that outweighed the benefits to individual plaintiffs when litigation became excessive or frivolous. The argument that lawsuit settlements come from somewhere, that money awarded in court does not appear from nowhere, but is extracted from institutions and communities, is not a South Park invention. It is a mainstream position in legal scholarship. But South Park made it accessible and memorable and funny in a way that no law review article ever could. The citizens of South Park hear the speech and turn on Gerald. He quickly agrees to stop filing lawsuits. The school is presumably restored. Kyle is presumably embarrassed by his father, and the episode moves on. But what lingers is not the resolution. What lingers is the image of Gerald moving into a larger and larger house, while the school behind him crumbles. That image is a legal argument rendered in animation, and it is more effective than any brief ever filed. Before we move on, if you are enjoying this Rearisis, please consider subscribing. It helps the channel tremendously. Gerald appears again in a legal context in Human Centipede, Season 15, Episode 1, which aired on April 27, 2011. This time, he is not the predator. He is the father. And the legal question at the center of the episode is one that every person watching has personally participated in without thinking about it. What happens when you agree to terms and conditions you have not read? The premise is that Kyle Broflovsky downloads the latest iTunes update and clicks agree on the terms and conditions without reading them. This is not unusual. Virtually no one reads software license agreements. Studies have estimated that it would take the average person approximately 76 working days per year to read every privacy policy and terms of service agreement they encounter. The agreements are designed not to be read. They are designed to be accepted, because acceptance is the point, not comprehension. In the episode, Apple exercises a clause hidden in the agreement that no one has read. Apple employees appear at South Park Elementary and physically seize Kyle. They inform him that his acceptance of the terms is legally binding. He signed a contract. They are exercising their contractual rights. Kyle is taken to a facility where Steve Jobs, the show's fictionalized version of the Apple founder, who had passed away later that same year, unveils his latest product, the Human Centipede. It is a device consisting of 3 human beings connected mouth to anus in a chain, inspired by the 2009 horror film, The Human Centipede. Kyle is the middle segment. A Japanese man named Junichi Takayama is at the front with an iPhone attached to his forehead. A woman is at the rear with an iPad attached to her. The 3 of them together constitute a single device that is part human, part centipede, part web browser, and part email client. The horror is played for comedy, and the comedy is effective, but the legal framework underneath the comedy is doing serious rearistical work. A lawyer watching this episode identifies at least 3 real doctrines being satirized simultaneously, and the show handles each one with a precision that suggests either legal research or an instinct for legal reasoning that borders on the professional. First, there is the doctrine of unconscionability. In American contract law, a court can refuse to enforce a contract, or any clause within a contract, if the terms are so unreasonable, so one-sided, so oppressive that no rational person would agree to them. Unconscionability comes in two varieties: procedural, which concerns the process by which the agreement was formed, and substantive, which concerns the content of the terms themselves. The iTunes terms in the episode are substantively unconscionable on their face. No reasonable person would agree to become part of a human centipede. The fact that Kyle clicked agree does not make the contract enforceable, because the law does not enforce agreements that are fundamentally unjust, even if both parties technically consented. Second, there is the doctrine of capacity. In the United States, minors generally cannot enter into binding contracts. Kyle is 9 years old. Any agreement he signs is voidable by his parents. The law treats minors as lacking the legal capacity to understand the implications of contractual obligations, which is why car rental companies will not rent to teenagers, and why credit card agreements require an adult cosigner for anyone under 18. The episode acknowledges this principle when Gerald's intervention ultimately voids Kyle's agreement. The mechanism through which Gerald voids it is absurd, involving an elaborate ritual performed by Apple Store employees called geniuses, who determine that a PC user parent can override an Apple agreement by creating a family account. But the underlying legal logic is sound. A minor's contract is not binding when a guardian objects. Third, and most subtly, there is the doctrine of informed consent, which in contract law is expressed as the requirement for a meeting of the minds. For a contract to be valid, both parties must understand what they are agreeing to. If one party buries material terms in language that is deliberately designed to be incomprehensible, or in a document so long that no reasonable person would read it, the other party cannot be said to have meaningfully consented to those terms. The issue of whether click-wrap agreements, the kind where you click a button to accept terms you have not read, constitute genuine consent, is one of the most actively litigated questions in modern contract law. Courts have generally upheld such agreements, but with increasing skepticism, and the trend in both European and American law has been toward requiring more meaningful disclosure of material terms. The show does not explain any of this. There is no character who delivers a lecture on unconscionability. There is no scene in which Gerald explains the concept of capacity to a judge. The episode simply builds a story in which the audience can feel, viscerally, the injustice of what is happening to Kyle. The audience does not need to know the legal terms. They can feel the wrongness. And then the show provides a resolution that, while absurd in its specifics, follows the actual logic of how contract disputes are resolved in the real world. Gerald does not break Kyle out of the Apple facility by force. He does not hire a team of mercenaries. He uses the legal system, imperfect and ritualistic and frustrating as it is, to void an agreement that should never have been enforceable in the first place. The resolution is a parody of legal process, but it is a parody that works because it mirrors the real process. There is also a fourth legal observation embedded in the episode that is easy to miss because it is not about a specific doctrine, but about a systemic problem. The episode aired on April 27th, 2011, less than 2 weeks after news reports revealed that Apple had been using tracking software built into iPhones and iPads to monitor users' locations without their explicit knowledge or consent. The real-world controversy was about privacy, about what consumers were unknowingly agreeing to when they clicked agree on terms they did not read. The episode does not address the tracking controversy directly. It does something more artful. It creates a fictional consequence so extreme, so nightmarishly absurd, that it recalibrates the viewer's sense of what is possible. If you would agree to become part of a human centipede without reading the terms, the episode asks, what else might you have agreed to? The fictional absurdity makes the real-world problem feel plausible, urgent, and personal in a way that a news report about tracking software never could. That is what a lawyer notices watching this episode. It is not about iTunes. It is not about Apple. It is about the fundamental gap between the fiction of informed consent and the reality of how people actually interact with legal agreements in a digital world. And that gap is one of the most significant unresolved problems in modern contract law. Before we move on, if you are enjoying this Rearisis, please consider subscribing. It helps the channel tremendously. Now consider what South Park does with its own legal exposure. Because every episode that depicts a real person, a real corporation, or a real institution is, in theory, an invitation to litigation. And the show has depicted hundreds of real people over its run. It has called them names that cannot be repeated. It has attributed fictional behavior to them that ranges from embarrassing to criminal. It has depicted them in sexual situations, in violent situations, in situations involving bodily fluids and functions. It has done this to politicians, to actors, to musicians, to religious leaders, to corporate executives, to athletes, and to at least one sitting president of the United States. How does the show get away with it? The answer is layered, and each layer reveals a different aspect of American law. The first layer is the most visible. It appears at the beginning of every episode. It is a block of text that most viewers skip past without reading, which is ironic given that an entire episode of the show is about the consequences of not reading text before agreeing to it. All characters and events in this show, even those based on real people, are entirely fictional. All celebrity voices are impersonated poorly. The following program contains coarse language, and due to its content, it should not be viewed by anyone. That is the South Park disclaimer, and it is doing considerably more legal work than its brevity suggests. The disclaimer has been a part of the show since its early seasons, though its format has been tweaked over the years. It was redesigned into its current form around the third season. Every standard episode begins with it. It is one of the most recognizable opening sequences in American television, and it is, line by line, a masterpiece of legal engineering. The first sentence is what is known in legal terminology as a fictitious person's disclaimer. These disclaimers originated in response to a specific legal event, a 1932 lawsuit against Metro-Goldwyn-Mayer over the film Rasputin and the Empress. In that film, a character named Princess Natasha was depicted being seduced by the Russian mystic Rasputin. The real Princess Irina Alexandrovna of Russia claimed the character was based on her and sued MGM for libel. The English Court of Appeal agreed that the princess had been defamed. After that case, film studios began adding disclaimers stating that all characters and events in their productions were fictitious and that any resemblance to real persons was coincidental. South Park's version of this disclaimer is different from the standard one in a way that is legally significant. Most disclaimers say something like, any resemblance to actual persons, living or dead, is purely coincidental. South Park's disclaimer says the characters are fictional, even those based on real people. That word even is doing the legal heavy lifting. It does not deny that the characters are based on real people. It acknowledges it. It says, yes, these characters are based on real people, and they are still entirely fictional. The even signals awareness and intention, which paradoxically strengthens the show's legal position. A standard disclaimer creates plausible deniability. South Park's disclaimer eliminates the need for deniability by openly admitting what it is doing, which makes it harder for a plaintiff to argue that the show was trying to pass off its depictions as factual. You cannot claim you were misled by a show that told you, before a single frame aired, that it was going to depict you fictionally, and that everything it depicted was made up. The second sentence, all celebrity voices are impersonated poorly, accomplishes something similar through a different mechanism. It preemptively addresses any potential claim of false endorsement or right of publicity. If a viewer believed that the real Tom Cruise was voicing his own character on South Park, that viewer might conclude that Cruise endorsed the show's depiction of him. The disclaimer eliminates this possibility by telling the audience that every celebrity voice is an impersonation. And the word poorly is not just self-deprecating humor, it is a legal argument. If the impersonation is acknowledged to be poor, then no reasonable viewer could mistake it for the real person. And the standard for defamation and right of publicity claims requires that a reasonable viewer be confused about whether the depiction represents fact or fiction. The third sentence is the one that makes lawyers smile. The following program contains coarse language, and due to its content, it should not be viewed by anyone. That is not a content warning. That is a legal inoculation disguised as a joke. By stating that no one should watch the show, the disclaimer preemptively undercuts any claim that a viewer was caught off guard by what they saw. If someone watches a show that explicitly told them not to watch it, and then complains about what they saw, the complaint has significantly less legal weight. The disclaimer functions, in effect, as a form of assumption of risk. You were warned. You chose to proceed. The consequences are yours. The combination of these three elements creates a legal shield that is far more effective than any individual element would be alone. The disclaimer tells you the characters are fictional. It tells you the voices are fake. It tells you the content is unsuitable for human consumption. And it tells you all of this before you have seen a single second of the actual show. By the time the first scene begins, the legal groundwork has already been laid. Anything that follows exists within a context that has been explicitly defined as fictional, parodic, and not intended for viewing by any person. Try building a defamation case on that foundation. The second layer of the show's legal protection operates at the level of individual episodes, and it involves a concept that is both deeply American and deeply uncomfortable: the distinction between statements of fact and expressions of opinion. When South Park depicts Tom Cruise refusing to come out of a closet, that is not a statement of fact. Tom Cruise did not, to anyone's knowledge, ever lock himself in a 10-year-old's closet and refuse to emerge while Nicole Kidman and John Travolta attempted to coax him out. No reasonable person watching the episode would believe that this event occurred. It is an expression of opinion, a satirical commentary on the persistent rumors about Cruise's personal life, delivered through the mechanism of metaphor. The metaphor is not subtle. The show is not trying to be clever about what it is suggesting, but the lack of subtlety is itself a form of legal protection, because the more obvious the satire, the less likely a reasonable viewer is to interpret it as a factual assertion. The legal framework for this reirisis comes from two Supreme Court decisions that are foundational to American defamation law. The first is New York Times Company versus Sullivan, decided in 1964, which established the actual malice standard for defamation claims brought by public figures. Under this standard, a public figure suing for defamation must prove not only that the defendant published a false statement of fact, but that the defendant did so with knowledge that the statement was false, or with reckless disregard for its truth. This is an extraordinarily difficult standard to meet, and it was designed to be difficult because the Supreme Court recognized that robust debate about public figures requires breathing room, and that an overly permissive defamation standard would chill the free expression that democracy depends on. The second decision is Hustler Magazine versus Falwell, decided in 1988, which extended the actual malice standard to claims for intentional infliction of emotional distress arising from parody. The case involved a Hustler Magazine parody advertisement that depicted the Reverend Jerry Falwell having his first time in an outhouse with his own mother. Falwell sued for libel and intentional infliction of emotional distress. The jury rejected the libel claim, finding that no reasonable person would believe the parody was asserting actual facts. But the jury awarded damages on the emotional distress claim. The Supreme Court reversed unanimously, holding that public figures cannot recover for emotional distress caused by parody unless the parody contains a false statement of fact made with actual malice. Since the parody was clearly not asserting facts, it was protected speech. South Park operates entirely within the space created by these two decisions. Every depiction of a real person on the show is so obviously exaggerated, so clearly satirical, so deliberately absurd that no reasonable viewer could mistake it for a factual assertion. Tom Cruise is not literally trapped in a closet. Kanye West does not literally fail to understand a joke. Barbra Streisand does not literally transform into Mecha Streisand. And the show's animation style itself functions as a legal defense, because the construction paper aesthetic is a constant visual reminder that what you are watching is not reality. It is a cartoon. The medium is the argument. But South Park goes further than simply avoiding factual assertions. It has developed a set of strategies, some deliberate and some possibly instinctive, that actively make litigation unattractive for potential plaintiffs. And the most fascinating of these strategies is one that most viewers have never heard of, but that legal scholars study with genuine interest. Before we move on, if you are enjoying this reirisis, please consider subscribing. It helps the channel tremendously. It is called the small penis rule, and its name is as blunt as its application. The concept was first described publicly by libel lawyer Leon Friedman in the New York Times in the late 1990s. The principle is straightforward. When an author creates a fictional character based on a real person and wants to minimize the risk of a defamation suit, the author gives the character a small penis. The reasoning is elegantly cynical. No man is going to step forward in public and declare, "That character with the small organ, that is me." The rule is not a formal legal doctrine. It has no statutory basis. It appears in no judicial opinion. It is a practical deterrent, a way of raising the personal cost of litigation to the point where the potential plaintiff decides the lawsuit is not worth the humiliation of identifying himself as the character being mocked. The concept gained broader attention after the novelist Michael Crichton used a version of it against a journalist named Michael Crowley. Crowley had written an unflattering article about Crichton in the New Republic in 2006, criticizing Crichton's novel State of Fear, which argued that climate change was a hoax. In his next novel, Next, published later that year, Crichton introduced a character named Mick Crowley, described as a Washington journalist, a Yale graduate, and a child rapist with a small penis. The real Crowley recognized the character immediately, called out Crichton publicly, and accused him of hiding behind the small penis rule to avoid consequences. But Crowley did not file a lawsuit. The deterrent worked exactly as intended. South Park has deployed this strategy with notable precision. In its 27th season, which aired in 2024, the show depicted a fictionalized version of the sitting president of the United States in several episodes. In one episode, titled Sermon on the Mount, the presidential character is shown naked in bed with Satan, who is presented as his romantic partner. Satan comments dismissively on the presidential character's anatomy, stating that he could not even see anything and that it is so small. The depiction is crude. It is also, viewed through a legal lens, strategically brilliant. For the real-world individual to bring a defamation claim, he would need to establish that the fictional character is based on him. In doing so, he would be publicly acknowledging the depiction, including the anatomical commentary, as a portrayal of himself. The small penis rule does not make the show legally immune. It makes litigation personally embarrassing for the plaintiff, which, in practice, is almost as effective as legal immunity. Legal commentators have noted that this particular deployment of the strategy is especially significant because the individual being satirized has a well-documented history of filing or threatening defamation lawsuits. The strategy is not just a legal shield, it is a dare. Sue us, the show says, and the first thing you will have to do in court is stand up and say, that cartoon character with the tiny penis, that is me. Media legal experts have observed that the show's use of the small penis rule, combined with its parody protections under the First Amendment, creates a nearly impenetrable defense against litigation from public figures. And there is a deeper point embedded in the strategy that connects it to the show's broader legal philosophy. The small penis rule works because it exploits vanity. It exploits the gap between a person's self-image and a person's willingness to endure public scrutiny. And that gap, the show suggests, is the real reason powerful people do not sue. Not because the law is on the show's side, although it is. Not because the First Amendment protects satire, although it does. But because the most powerful people in the world are also the most image conscious. And the legal system, for all its machinery, cannot protect you from being laughed at. That is the ultimate defense, not a legal precedent, not a statutory exception. Laughter. Now let us turn to the episode where South Park did not just use the law as a shield or as a subject. It changed the law. Canada on Strike, Season 12, Episode 4, aired on April 2nd, 2008. The episode satirizes the 2007 to 2008 Writers Guild of America strike and the emerging culture of internet viral videos. In the episode, the character Butters Stotch creates a video in which he performs his own animated version of the song What in the Butt, a real viral video by the artist Samwell that had become an internet phenomenon in 2007. Butters performs the same dance. The video looks similar. The references are unmistakable. The copyright holder for the original video, a company called Brown Mark Films, was not amused. In 2010, more than 2 years after the episode aired, Brown Mark filed a copyright infringement lawsuit in the United States District Court for the Eastern District of Wisconsin against Comedy Partners, MTV Networks, Paramount Home Entertainment, Viacom International, and South Park Digital Studios. The lawsuit alleged that the South Park video infringed Brown Mark's copyright in the original What in the Butt video. The defense argued that the South Park version was an obvious parody and therefore constituted fair use under Section 107 of the Copyright Act. Fair use is a defense, not a right. It is an affirmative defense, which means the defendant bears the burden of proving it, and it is determined by weighing 4 factors that the statute lays out. First, the purpose and character of the use, including whether the use is commercial or transformative. Second, the nature of the copyrighted work. Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And fourth, the effect of the use upon the potential market for the copyrighted work. Parody has been recognized as a potentially fair use since the Supreme Court's 1994 decision in Campbell v. Acuff Rose Music Inc., in which 2 live crews' parody of Roy Orbison's Oh Pretty Woman was found to be transformative. The Campbell Court held that a parody that targets the original work and uses elements of the original to comment on or criticize it can constitute fair use, even if the parody is commercial in nature. The key inquiry is whether the new work is transformative, whether it adds something new, with a further purpose or different character, rather than simply superseding the original. But the South Park case did something that no previous case had done. The defense did not just argue fair use, it argued that the case should be dismissed at the earliest possible stage of litigation, before discovery, before depositions, before the expensive and time-consuming pretrial process that makes copyright litigation such an effective weapon against defendants who cannot afford to fight. The defense filed a motion to dismiss under Federal Rule of Civil Procedure 12b-6, arguing that a judge could determine the fair use question simply by watching the two videos side by side. No further evidence was needed. The parody was obvious. The case should be over before it began. On July 6, 2011, Judge J.P. Stadtmuller of the Eastern District of Wisconsin agreed. He dismissed the case, concluding that the South Park video was a classic parody, and that viewing the two videos provided everything he needed to determine fair use. Brownmark appealed. On June 7, 2012, a unanimous panel of the 7th Circuit Court of Appeals affirmed the dismissal, calling Judge Stadtmuller's opinion well-reasoned and delightful. The court held that the district court had properly decided the fair use question at an early stage of the proceedings, without requiring discovery, and that the South Park video was a protected parody. The court noted that Brownmark's broad discovery requests, which included demands for all relevant video images, internal communications, and licensing information, gave the plaintiff the appearance of a copyright troll. That phrase, copyright troll, entered the official judicial record of a case involving an animated show about 4 children in Colorado. The Electronic Frontier Foundation filed an amicus brief in support of South Park, characterizing the lawsuit as an example of the rapidly escalating problem of copyright trolls. That is, entities that embrace copyright litigation as a business model. The significance of this ruling extends far beyond a single case about a single episode of a single television show. Brownmark Films versus Comedy Partners was the first federal appellate decision to extend early dismissal reasoning into the realm of copyright fair use. Courts had long recognized, in contexts like defamation and the right of publicity, that early dismissal of weak claims was essential to prevent the chilling of protected speech. The 7th Circuit's decision applied the same reasoning to copyright, holding that when a fair use defense is obvious, courts should not force defendants to endure the expense and burden of full litigation just because the plaintiff is willing to file a complaint. The ruling, in effect, created a legal fast lane for cases where the parody is self-evident, allowing courts to protect creators from being bullied into silence or settlement by the sheer financial weight of defending a lawsuit. The Hollywood Reporter later called this decision one of the most influential court rulings in entertainment law in a 5-year period. A case about Butters dancing in a cartoon. The decision is now cited in legal scholarship alongside Ashcroft versus Iqbal, a 2009 Supreme Court opinion that established heightened pleading standards for federal civil complaints. The Legal Academy treats Brownmark as a landmark, and its origins are in a 22-minute animated episode about internet fame and Canadian labor disputes. Before we move on, if you are enjoying this reresis, please consider subscribing. It helps the channel tremendously. The show's engagement with free speech is not confined to its courtroom episodes or its legal defense strategies. In several remarkable episodes, the show turned the camera directly on the machinery of censorship and made the audience watch it operate. Trapped in the Closet, Season 9, Episode 12, aired on November 16, 2005. The episode was written and directed by Trey Parker, who was credited as John Smith. That credit is not a joke. It is a legal strategy, and understanding why it exists requires understanding what the episode was targeting. The episode satirizes the Church of Scientology. Stan takes a free personality test offered by Scientologists, scores unusually high on a Thetan-level assessment, and is declared the reincarnation of L. Ron Hubbard, the founder of the church. Scientologists converge on the Marsh House. The president of the church arrives, and Tom Cruise, who in real life is one of the most prominent Scientologists in the world, comes to meet Stan and asks what Stan thinks of his acting. Stan says Cruise is okay, but not as good as Leonardo DiCaprio, Gene Hackman, or that guy who played Napoleon Dynamite. Cruz is devastated and locks himself in Stan's closet. He refuses to come out. The double meaning is not subtle. The show spends the rest of the episode with various characters begging Tom Cruise to come out of the closet, while Cruise insists from inside the closet that he is not in the closet. Nicole Kidman tries, John Travolta tries, and then also refuses to come out. R. Kelly tries, and then pulls out a gun. Meanwhile, the president of Scientology reveals the church's origin story to Stan, and the episode depicts it on screen with a caption at the bottom of the frame reading, "This is what Scientologists actually believe." That caption is legally significant. It serves the same function as the Hustler magazine disclaimer. It tells the audience that what they are seeing is presented as factual content about the real beliefs of a real organization, not as a South Park invention. The show is reporting, not fabricating. And by making this distinction explicit, the show insulates itself from any claim that it misrepresented Scientology's beliefs. They are not making this up. This is what the church teaches. The episode ends with Stan declaring that Scientology is a big, fat, global scam. The president of the church threatens to sue. Cruise threatens to sue, specifically in England, which is significant because English defamation law historically placed a lighter burden on plaintiffs than American law, making England a favored jurisdiction for defamation tourism. Stan shouts back, "Go ahead, sue me," and then the credits roll, and every name is John Smith or Jane Smith. Parker and Stone made a specific legal decision with those credits. The Church of Scientology has a well-documented history of using litigation, investigation, and intimidation against individuals who criticize it. The Church's fair game policy, which was formally rescinded in 1968, but which critics allege has continued in practice, designated critics as enemies who could be deprived of property or injured by any means by any Scientologist without any discipline of the Scientologist. Parker and Stone knew that the church might not just threaten to sue. The church might investigate. It might target individuals. And the most vulnerable targets would not be Parker and Stone, who have resources and public profiles that make them difficult to intimidate. The most vulnerable targets would be the junior animators, the production assistants, the voice technicians, the people who worked on the episode because it was their job and who had no say in its content. The John Smith credits are a legal firewall. They ensure that if any legal action or any investigative effort were directed at the people who made the episode, the only names available would be Parker and Stone's. Everyone else is anonymous. The credits do not just hide identities. They redirect exposure, channeling any potential legal or extra-legal consequences toward the two people who are best equipped to handle them and away from the people who are most vulnerable. Reports later confirmed that Scientology did, in fact, investigate the South Park production team. According to accounts that emerged publicly, representatives of the church went through the production team's trash and attempted to get a private investigator hired as an animator or writer at the South Park studio in order to gather information about the show's creators. Parker and Stone have spoken about being aware of these efforts. The credits were not paranoia. They were prescience. The rebroadcast controversy added another dimension. A rerun of Trapped in the Closet was scheduled for March 15th, 2006. It was pulled from the schedule and replaced with a different episode. Comedy Central stated the substitution was a tribute to Isaac Hayes, who had recently announced his departure from the show. But multiple reports indicated that the actual reason was pressure from Tom Cruise, who allegedly threatened to withdraw from promotional obligations for Mission Impossible 3, a Paramount Pictures film. Paramount was a subsidiary of Viacom. Viacom owned Comedy Central. The corporate structure allowed Cruise to apply pressure without ever entering a courtroom. The threat was economic, not legal. And economic threats, unlike legal threats, do not require a judge. Matt Stone was direct about the stakes. If they had not put this episode back on the air, we would have had serious issues, and we would not be doing anything else with them. The episode did eventually re-air that summer. It was released on DVD. The alleged request to suppress it permanently was ignored. But the incident illustrates a truth about free speech that South Park has been documenting for its entire run. The First Amendment protects you from the government. It does not protect you from your own corporate parent. And the gap between those two protections is where most real-world censorship happens. Before we move on, if you are enjoying this Reresis, please consider subscribing. It helps the channel tremendously. 4 years after Trapped in the Closet, the show pushed the censorship question further than it had ever gone. And the result was the most significant confrontation between a creative work and its own network in the history of American television. Episodes 200 and 201, the 5th and 6th episodes of Season 14, aired on April 14th and April 21st, 2010. They were written and directed by Trey Parker. They were conceived as a celebration of the show's 200th episode, and they were designed from the ground up to test every legal and institutional boundary the show had ever encountered. The plot of episode 200 is a legal premise disguised as an action comedy. Every celebrity who has ever been mocked by the residents of South Park, dozens of them, gathers together to file a class action lawsuit against the town. Tom Cruise leads the group. The legal structure is immediately recognizable. A class action requires a group of plaintiffs with a common injury seeking a common remedy. The celebrities' common injury is that they have been ridiculed. Their common remedy is the power to never be ridiculed again. Cruise offers to drop the lawsuit if the town produces the Prophet Muhammad, who, in the show's mythology, possesses a supernatural power that prevents anyone from mocking him. The celebrities want that power. They want immunity from satire. The legal satire is operating on multiple levels. On one level, the show is mocking the idea that being mocked constitutes a legally cognizable injury. Defamation law does not protect people from being made fun of. It protects them from false statements of fact made with actual malice. Being depicted in an unflattering cartoon is not the same as being defamed, and any lawyer would tell the celebrity plaintiffs that their class action has no merit. On another level, the show is making a broader argument about the relationship between law and power. The celebrities are not using the lawsuit because they think they will win. They are using the lawsuit as leverage, as a tool to force the town to give them something they want. The law is not serving justice. The law is serving ambition. But the events that surrounded these episodes made the fictional legal drama irrelevant. Before episode 201 aired, a website associated with an Islamist organization called Revolution Muslim posted a warning that Parker and Stone risked being murdered for their depiction of Muhammad. The post included a photograph of Theo van Gogh, the Dutch filmmaker who had been stabbed and shot to death on an Amsterdam street in 2004 after directing a film critical of Islam. The post stated that Parker and Stone will probably wind up like Theo van Gogh for airing this show. Comedy Central's response was to censor the episode. When 201 aired, every reference to Muhammad's name was bleeped. The bleeping was not done by Parker and Stone. It was done by the network. The entire 2-minute closing speech by Kyle, in which the characters deliver the traditional "I learned something today" monologue, was bleeped in its entirety. The audience heard nothing. The screen showed Kyle speaking. The audio was a continuous tone. Viewers initially assumed the bleeping was a meta joke, a satirical commentary on censorship delivered through the act of censorship itself. Parker and Stone publicly and repeatedly denied this. The bleeping was real. The network had censored their show against their will. The uncensored speech, which was eventually leaked when a user discovered it on South Park Studios servers in 2014 and retrieved it using specialized software, argues that the only way to prevent violence from silencing speech is to refuse to be silenced. The irony is total. The speech about refusing to let threats suppress speech was itself suppressed by a corporate entity responding to threats. The medium contradicted the message. The Container refuted the content. Both episodes, along with Super Best Friends from 2001 and the Cartoon Wars 2-parter from 2006, were removed from all legal streaming platforms. They are not available on Paramount Plus. They are not available on any digital storefront. They were among 5 episodes excluded when the series was transferred to HBO Max in 2020. All 5 episodes share a single characteristic. They depict Muhammad. No other episodes have been removed. Despite the hundreds of episodes that have generated controversy, complaints, boycott threats, and public outrage from religious organizations, political groups, foreign governments, and individual celebrities, the legal dimension of this erasure is worth sitting with. No court ordered these episodes removed. No judge found them defamatory, obscene, or illegal. They were removed by a corporate decision, a calculation that the risk of violence outweighed the value of the speech. That calculation may have been reasonable. The threats were real. People have died for depicting Muhammad in satirical contexts. But the fact that it was a corporate decision and not a legal one matters, because it means the legal protections that South Park has spent decades building, the parody defenses, the fair use precedents, the disclaimer, the small penis rule, all of it can be bypassed entirely by a single executive in a conference room who decides the content is not worth the liability. The law protects you from the government. The corporation protects you from nothing. The Cartoon Wars two-parter, Season 10, Episodes 3 and 4, which aired on April 5th and April 12th, 2006, engaged with the same question 2 years earlier and in a more concentrated form. The plot centers on a fictional episode of Family Guy that is about to depict Muhammad. The town of South Park panics. Citizens bury their heads in sand. Cartman races to Hollywood to get the Family Guy episode pulled, motivated not by religious sensitivity, but by his personal hatred for the show. Kyle races to stop him, arguing that pulling the episode would set a precedent that destroys free speech. There is a scene in which the President of the United States is asked why he does not simply order the network to cancel the Family Guy episode. The President explains that the episode is protected under the First Amendment. The reporters in the room, people who depend on the First Amendment for their careers, for their ability to ask questions, for their right to publish stories without government interference, have never heard of it. They mock it. The scene is comedy. It is also a disturbingly precise observation about how free speech protections are taken for granted by the people who benefit from them most, until the moment those protections are needed to protect someone else's speech, at which point they become suddenly unfamiliar. Kyle's argument in the second part of the two-parter is drawn directly from conversations Parker and Stone had with Comedy Central executives during the production of the episodes. Kyle argues that if they pull one episode because of threats, they create a precedent that any group willing to threaten violence can censor any content. That the principle of free speech is meaningless if it only applies to speech that no one objects to. These arguments are foundational in First Amendment jurisprudence. They appear in Supreme Court opinions, in the writings of philosophers and legal scholars, in the founding documents of the American Republic. South Park did not invent them, but South Park made them accessible to an audience of millions who have never read a Supreme Court opinion and probably never will. And it made them vivid by embedding them in a story about a 9-year-old boy chasing a sociopath across America on a tricycle, while the world waits to see if a cartoon about a cartoon will air a cartoon. Comedy Central ultimately refused to show Muhammad in the episode. The scene where Muhammad would have appeared was replaced with a title card reading, "Comedy Central has refused to broadcast an image of Muhammad on their network." That title card is, in legal and rhetorical terms, a more powerful statement than the original image would have been. It does not depict Muhammad. It depicts the refusal to depict Muhammad. And the refusal itself becomes the argument, because the audience can see in the empty space where the image would have been exactly what the network is afraid of. The censorship creates the content. The absence is the presence. The show found a way to make the network's legal caution into a stronger argument for free speech than the original depiction could ever have been. Before we move on, if you are enjoying this Reresis, please consider subscribing. It helps the channel tremendously. There are smaller legal moments throughout the show's run that accumulate into a pattern. Each one, taken individually, is a joke. Taken together, they constitute a body of legal criticism that is more sustained and more internally consistent than most published legal commentary. Butt Out, Season 7, Episode 13, which aired on December 3rd, 2003, satirizes the tobacco litigation industry. The boys are caught smoking and blame the tobacco companies to avoid being grounded. Rob Reiner arrives to lead an anti-smoking crusade, and the episode plays out as a war between Reiner's anti-smoking lobby and the tobacco industry, with the boys caught in the middle. The tobacco company employees are depicted as cheerful, reasonable people who believe in personal responsibility and informed consumer choice. Reiner and his associates are depicted as manipulative zealots who forge evidence, exploit children, and are willing to murder a child to stage a convincing anti-smoking commercial. The episode's legal commentary is not about the merits of anti-smoking legislation. It is about the litigation strategy underlying the tobacco lawsuits of the 1990s, which produced the largest civil settlement in American history. The Master Settlement Agreement of 1998 required the major tobacco companies to pay a combined $206 billion over 25 years to 46 states. The episode does not question whether tobacco companies caused harm. It questions whether the legal process used to hold them accountable was honest. Reiner's plan to forge photographic evidence of the tobacco company giving cigarettes to children mirrors documented concerns about evidence manipulation in civil litigation. Kyle's final observation, that the boys smoked of their own free will and that nobody learned their lesson, undermines the episode's own structure by refusing to deliver the moral it has been building toward. The law says one thing, reality says another. And Kyle, the character who usually delivers the moral, cannot reconcile them. Reverse Cowgirl, Season 16, Episode 1, which aired on March 14th, 2012, takes the absurdity of litigation to its furthest logical extreme. When Clyde Donovan's mother dies in a freak toilet accident after Clyde leaves the seat up, the boys visit a lawyer from the firm of Hoffman and Turk, who specializes in suing the dead. The lawyer proposes to sue Sir John Harrington, the Elizabethan courtier credited with inventing the flush toilet, for designing a product that contributed to Clyde's mother's death. Harrington died in 1612. The lawyer conducts a seance, a seance-like ritual designed to contact the inventor's spirit for the purpose of serving legal papers. The session costs $3,000, extracted from Clyde's mother's life insurance. The spirit, when contacted, demands $100 tips for each piece of information provided. The lawyer is eventually exposed as a fraud. The legal satire is not about the specific absurdity of suing a dead man. It is about the culture of blame shifting that drives frivolous litigation. Clyde's mother died because Clyde left the toilet seat up. That is a domestic accident. It is not a product liability case. But the legal system, as depicted in the show, is perfectly willing to convert a personal failure into a cause of action against a third party, because the system does not distinguish between legitimate and illegitimate grief. It monetizes both equally. You're Not Yelping, Season 19, Episode 4, which aired on October 14th, 2015, addresses the legal boundary between consumer review and defamation. The episode depicts the residents of South Park becoming obsessed with Yelp reviewing, using their status as reviewers to extort free food and special treatment from restaurants. Gerald Broflovsky is among them, writing a 50-page review of an Applebee's that reads like a doctoral thesis before giving the restaurant 2.5 stars because the street parking was inadequate. The restaurants, when they fight back by banning Yelp reviewers, discover that the social power of online reviews exists in a legal gray area. A negative review is an expression of opinion, protected by the First Amendment. A review that contains false statements of fact about a business could constitute defamation. But the line between opinion and fact in an online review is notoriously difficult to draw, and courts have struggled with this question extensively. The episode's genius is that it does not try to answer the legal question. It dramatizes the question. It shows what happens when everyone believes they have the legal right to say whatever they want about a business, and when the businesses have no effective legal remedy because the cost of litigating a defamation claim over a restaurant review exceeds the damage the review causes. The legal system provides a theoretical remedy. The practical cost of that remedy makes it unavailable. That gap between theory and practice is, once again, where the legal Rearisis lives. Shortly after the episode aired, a parody news site called NBC.com.co published a fake story claiming that Yelp was suing the creators of South Park for $10 million for defamation. Several mainstream news outlets reported the story as fact before realizing it was fabricated. Yelp responded by quoting Abraham Lincoln, "You cannot believe everything you read on the internet." The irony of a fake lawsuit story generated by a show about the legal vulnerability of online statements was, presumably, not lost on anyone. Chicken Lover Season 2, Episode 4, which aired on May 27th, 1998, approaches the law from a different angle entirely. The question of what law enforcement actually is and what happens when it disappears. When Officer Barbrady, South Park's sole police officer, resigns after it is revealed that he is illiterate, the town immediately descends into anarchy. Fires break out. Looting begins. Citizens turn on each other. The episode plays the descent into chaos as immediate and total, the joke being that a single, manifestly incompetent police officer was the only thing standing between civilization and barbarism. Cartman is deputized to maintain order in Barbrady's absence. He takes to the role with terrifying enthusiasm, patrolling the town on his big wheel and beating citizens with a nightstick while demanding that they respect my authority. The first deployment of that iconic catchphrase is not just a character moment. It is a commentary on the relationship between authority and violence, on the observation that the person most eager to enforce the law is often the person least qualified to understand it. Cartman does not know what the laws are. He does not care what the laws are. He cares about the power that comes with enforcing them. And the show, by giving that power to an 8-year-old sociopath, asks the audience to consider how different Cartman's behavior really is from what they see on the news. Barbrady's reinstatement, after he learns to read and catches the criminal, is followed by a gift from the bookmobile driver, a copy of Ayn Rand's Atlas Shrugged. After reading it, Barbrady declares that reading totally sucks and that he is never going to read again. The final joke undermines the entire premise of the episode. The system is restored. The officer is back. But nothing has been learned, nothing has changed, and the law is still being enforced by a person who has no understanding of what it means or why it matters. Before we move on, if you are enjoying this Rearisis, please consider subscribing. It helps the channel tremendously. There is one more dimension of the show's legal engagement that deserves extended attention, and it is the dimension that connects everything we have discussed tonight into a single argument. The show does not just satirize the law, it inhabits the law. Every episode that depicts a real person is a legal event. Every joke about a celebrity is a test of the boundary between protected speech and actionable defamation. Every parody is a potential fair use case. Every disclaimer is a legal filing in everything but name. The show exists inside the legal system, not outside it. It is not commenting on the law from a safe distance. It is operating within the law, pushing against its boundaries, testing its limits, and in the process, expanding those boundaries for everyone who creates satirical content. Consider what the show has built over 27 seasons. It has a disclaimer that inoculates it against defamation claims. It has a precedent-setting appellate decision that protects it from copyright trolls. It has deployed the small penis rule to deter litigation from public figures. It has used pseudonymous credits to protect its staff from retaliatory investigation. It has generated a legal vocabulary, the Chewbacca defense, that is now part of the professional language of the American bar. And it has done all of this while maintaining a perfect record: 0 successful lawsuits. That record is not the result of the show being timid. It is the result of the show understanding, with remarkable precision, exactly where the legal boundaries are, and exactly how hard it can push against them without crossing them. The show's legal intelligence is not separate from its comedic intelligence. They are the same intelligence applied to different domains. The show is funny because it sees clearly, and it sees the law more clearly than most legal commentators, because it approaches the law not as an abstraction, but as a practical problem. How do we say what we want to say without getting sued? That is the question the show answers every week, and the answer, refined across thousands of episodes, constitutes a body of practical legal knowledge that no law school teaches, because no law school needs to. Gerald Broflovsky remains the show's avatar for this understanding. He is the character who knows how the system works, who can navigate it, who can exploit it, who can be exploited by it. He is not a hero. He is not a villain. He is a lawyer. And the show's refusal to categorize him, its insistence on showing him as both the defender and the destroyer, as both the father who saves his son and the opportunist who bankrupts a school system, is the most honest portrait of the legal profession that American television has ever produced. Gerald is not an exception. Gerald is the rule. The legal system produces Geralds. It is designed to produce Geralds. And until the incentives change, it will go on producing them. The show knows this. It has always known this. And the thing that makes its legal commentary so effective is that it never preaches. It never lectures. It never stops being a cartoon about 4 children in Colorado who cannot seem to stay out of trouble. It just shows you the law, the way the law actually works, the way it protects and fails to protect, the way it can be wielded by the powerful and the powerless, the way it shapes the boundaries of what can be said and what cannot. And it trusts you to draw your own conclusions. The conclusions are not comfortable. They are not supposed to be comfortable, but they are accurate. And accuracy, in a world that rewards comfortable lies, is the most radical form of comedy there is. South Park is, in the end, a show about freedom, not the abstract, philosophical kind that politicians invoke in speeches, the specific, legal, procedural kind. The kind that has case numbers and judicial opinions and statutory defenses. The kind that was established in courtrooms by lawyers, arguing about the meaning of individual words in a document written in the 18th century. The kind that makes it possible for two men from Colorado to spend 27 years calling the most powerful people in the world by their worst names, in the worst possible contexts, on national television, and walk away without paying a dime. That freedom is not automatic. It is not natural. It was not given. It was built case by case, precedent by precedent, argument by argument over centuries. And South Park, whether it knows it or not, whether it intends to or not, whether its creators would ever describe their work this way or not, is one of the most effective ongoing demonstrations of that freedom in action. Not because it talks about freedom, because it uses it every week, every season, every episode, without stopping. The Chewbacca defense is in the legal dictionary. Brown Mark Films versus Comedy Partners is in the case law. The disclaimer is on every episode. Gerald Broflovsky is still practicing, and the show is still on the air, still calling people names, still animating things that cannot be described in polite company, still pushing against the boundaries of what is legally permissible, and finding, every time, that the boundaries hold. That is what a lawyer notices when they watch South Park. Not the jokes, not the vulgarity, not the construction paper, the architecture, the invisible legal structure that holds the whole thing up. The law underneath the comedy, supporting it, protecting it, making it possible. The law that most viewers never see because the show is too busy making them laugh to point it out. And maybe that is the most South Park thing of all. That the deepest legal commentary on American television is hidden inside a show that opens every episode by telling you it should not be viewed by anyone. If you enjoyed this video essay, make sure to subscribe. Thanks for watching, and I will see you in the next.